This client retained us for asset protection, business restructuring, and estate planning. She's a nurse practitioner and a mom of two. She lives in Massachusetts, where the estate tax exemption limit is $2 million. The first thing we wanted to show her was how huge her tax bill was going to be if we didn't take action immediately, and this is how we broke it down. We listed out her probate assets from her non-probate assets. On the left, her probate assets includes a primary house with $170,000 in equity, 2 investment properties with a combined total of $220,000 in equity. She has a checkings and savings account with Bank of America with about $95,000. But because these accounts are not joint and she didn't have a payable on death, they would go through probate. She also has a brokerage account for trading. Again, no beneficiary listed, so this account would also go through probate. And the worst of this is that all of these accounts would be frozen for about 1 to 2 years because that's how long the probate process could take. She has personal property worth about $30,000 and a med spa LLC worth about $88,000. This side totaled about $913,000. To the right, her non-probate assets includes her retirement accounts, a 401k, and IRA. Her sons are listed as primary beneficiaries with a 50-50 split. She has a life insurance policy for $2 million and a solo 401k. Her sons are also listed as primary beneficiaries with the 50-50 split. With her life insurance policy, this side totaled almost $2.25 million, bringing her entire taxable estate to $3.1 million, which means her family is looking at a $91,000 tax bill, not including probate and lawyer fees. Now watch part 2 to see how we restructured everything. Here's what we did for the nurse practitioner in my last video. We created a living revocable trust, and although it doesn't provide asset protection or tax benefits by itself, we've implemented other strategies for those concerns. Step 2, we created an irrevocable life insurance trust so that we could remove that $2 million from her taxable estate. Step 3, we put her primary home and savings account directly in the trust by retitling those assets. Her retirement accounts includes a 401k, an IRA, and a solo IRA. We didn't retitle them. We updated the beneficiary to the living revocable trust. We created a Wyoming LLC to own her brokerage account because she does trade, so we want to protect that from outside liability creditors. We created a second Wyoming LLC for her real estate portfolio because it is something she's looking to expand, so we wanted to lay the foundation correctly. Under the Wyoming LLC, we created 2 subsidiary LLCs, one for each property. We created a Wyoming LLC, and that owns her Med Spa LLC, as well as this Asset Holding LLC to the right. The Asset LLC leases its assets to the Med Spa. Also, her living revocable trust includes 2 sub-trusts within them, one for each child, and the trusts become effective upon her death. They are embedded with conditions, incentives, and of course a spendthrift clause to ensure their assets are protected from their creditors. Then we completed her plan with the side dishes. You see, the trust is the main course, but don't forget about the side dishes. And I'm sorry that I'm blocking you, but basically what this says is a pour-over will, power of attorney, healthcare proxy, business succession plan, and a living will. Here's what we did. This married couple came to us for asset protection and generational longevity. So let me show you how we structure them. Part 1. The first layer of any Nexus framework is a living revocable trust. In the case of this married couple, we did a joint trust because they have joint assets. $3.1 million in assets makes their estate a taxable one in Massachusetts. So we set this up to be a credit shelter trust. When the first spouse dies, the trust splits into an A-B trust. Trust A serves as the surviving spouse's trust, and the surviving spouse maintains control and can make changes. B is a bypass trust. The bypass trust becomes irrevocable after the death of the first spouse. This way, the surviving spouse can't switch it up, but the surviving spouse can still receive income from the B trust. When the surviving spouse dies, the AB trust terminates and all the principal and income from both trusts waterfall into a subtrust for their daughter. The daughter's subtrust is irrevocable, meaning it's protected from her creditors, lawsuits, and divorcing spouses. This ensures the wealth stays within the bloodline. As a condition, the daughter must create her own revocable living trust, and if she has a child, a subtrust must be created for that child. See how this works? The grandchild's subtrust is funded from the daughter's subtrust, which came from the AB trust. And when that grandchild has a child, a new trust must be created for that child. This keeps going generation after generation. This is complex because of legal nuances like the rules against perpetuities, so don't try this at home. But stay tuned for part 2 for their business and real estate asset protection strategy. This asks which state is better for setting up holding companies. There are 2 states that are always mentioned, Delaware and Wyoming. So let's compare the 2. In Delaware, the filing fee is $110, and it usually takes about 3 to 5 business days to get approved. You do get anonymity, which is great for anyone who wants privacy of ownership. Delaware does have a $300 franchise tax that's due every year, regardless if your company made any money. However, that doesn't seem so bad considering the charging order protection you get, which helps keep your personal creditors from seizing your LLC assets. Corporations really love Delaware because of the Court of Chancery that was established in the 1800s. It's a very sophisticated court system. Delaware does have a gross receipts tax, but as a holding company with no in-state sales, that generally won't affect you. Same with their state income tax. If you don't live in Delaware and your company doesn't earn any money in Delaware, you are generally not subject to income taxes. Now let's take a look at Wyoming. Filing is cheaper by $10, so about $100. Approval is quicker. You get same day approval, and you still get anonymity, no public listing of owners. And there's no franchise tax, just a $60 annual report fee. You also get charging order protection, just like in Delaware. Wyoming does have a court of chancery, but it's recently established, 2019 to be exact. So it's not as sophisticated as Delaware. But hey, on the bright side, there's no state income tax at all. However, they do have a sales tax. But again, as a holding company, you're not selling anything, so it's irrelevant. So if you're forming a holding company and you're not actually living or doing business in these states, Wyoming usually comes out on top, lower annual costs, no income tax, and same level of protection and privacy as Delaware. And ask which state. If you're a real estate investor looking for privacy, anonymity, and a layer of asset protection, this is what I call the real estate nexus. We start at the top with a revocable trust. Now, this isn't for asset protection, it's for succession planning. If you pass away, your LLC avoids probate. That trust then owns holding companies. We use two separate holding companies. The left side is for passive income, like buy and holds. The right side is for active income, such as flips. Let's break down the passive side first. Your trust owns a COPE holding company. That's a company formed in a state that provides charging order protection, which we'll break down in part 2. That company then owns property-specific LLCs, one for each rental. Each property holding LLC must be registered in the state where the property is located, or you'll need to file as a foreign entity. This holding company is taxed either as a disregarded entity or a partnership, depending on how many members are involved. On the active side, your trust also owns a second COPE holding company. This holding company owns your Flip 1, Flip 2, and short-term rental LLCs. This holding company is taxed as an S Corp because active income is subject to self-employment tax, and the S Corp structure helps reduce that tax burden. The trust also owns a property management company structured separately from both holding companies. It might be taxed as an S Corp or C Corp. C Corp if you want fringe benefits like health insurance. And make sure you have the right type of insurance. Property insurance for the building, liability insurance to protect against lawsuits, umbrella policy to cover the gaps. We may consider irrevocable trust for true asset protection if your portfolio or situation warrants it. If you're a real estate, the best state to form your LLC is generally the state where you're actually operating your business. And to figure that out, courts apply what's called the nerve center test. Your business's nerve center is the place where key decisions are being made, where day-to-day control happens. So for example, if you form an LLC in Wyoming, but you're actually running your business from Florida, Wyoming is your state of formation or incorporation, but Florida is your nerve center. That means that irregardless of Wyoming's filing, you'll also need to register as a foreign entity in Florida, follow Florida's business laws, and possibly pay Florida taxes. So to figure out your nerve center, I want you to ask yourself these questions. Where do you live and run the business from? Where do you or your team make executive decisions? Where is your business bank account managed? Where do you sign contracts and handle operations? Where is your business address listed on your website, invoices, social media? And for my e-commerce business owners, your nerve center is likely your home office or your workspace because that's where control and coordination happens. So Shanice, when does it make sense to form an entity in Wyoming or Delaware or Nevada? Stay tuned for part 2.
Can you talk about the danger in not funding your trust and then to give us the step?
There are three main types of holding companies. Let's start with a pure holding company. A pure holding company's only job is to own other companies. It doesn't sell products, offer services, or run daily operations itself. Instead, it makes money through its subs. Think of Berkshire Hathaway. It owns companies like Geico and Dairy Queen, but each of those businesses run independently. Next, we have a mixed holding company, also called a parent company. This type of structure does both. It owns subsidiaries and runs its own business operations at the same time. It earns money from its own products and services and from its subs. Think of Johnson & Johnson. They own an entire portfolio of brands, but they also manage parts of their business directly. Then there's the intermediate holding company. You don't see this as often. It owns subsidiaries, but it's also owned by a bigger parent company. This setup is common when a business is scaling and needs an extra layer of separation to manage risk. Oh, and one more thing about pure holding companies. Not all pure holding companies are set up to own other businesses. Some are specifically designed to hold high value assets like intellectual property, equipment, trucks, real estate, crypto, or other major investments. The goal here is asset protection.
The best state to form your LLC is
If you're a ask which state is better for setting up holding companies, if you're a real estate investor looking for privacy, anonymity, and a layer of asset protection, this is what I call the real estate nexus. We start at the top with a revocable trust. Now, this isn't for asset protection, it's for succession planning. If you pass away, your LLC avoids probate. That trust then owns holding companies.
the best state to form your LLC is generally.
Can you talk about
There are three main types of holding companies. Let's start with a pure holding company. A pure holding company's only job is to own other companies. It doesn't. Welcome back to the Holding Company Series Part 2. So let's talk about that pure holding company from my last video and how it actually works and how it gets paid. So remember, a pure holding company does not do the day-to-day work. It owns the company or assets that make the money. So let's say you own a trucking business LLC. Instead of running that business directly, you set up a holding company that owns the trucking LLC and the asset. Your trucking LLC is the one doing all the work. It's booking the clients, it's hauling the loads, it's paying the drivers, it's managing the operations. And your holding company's job is to protect the business while making key decisions like when to invest, when to sell, where to expand, when to expand, and other things. But here's how it gets paid. One, lease payments that the trucking LLC is paying to the holding company for using its vehicles. Number two is management fees. The trucking LLC is paying the holding company for strategic oversight, securing loans, and managing compliance. Number three is dividends and distributions. The trucking LLC is paying the holding company a portion of its profits because it's the owner. So the trucking LLC is earning the money and the holding company controls where it goes. Let me know if that made sense or you want me to draw it out. Either way, stay tuned for part 3. Welcome back to the holding. So a lot of you commented on my last post asking me to draw it out for you. So here it is. Let's use the same trucking example. You form a trucking LLC. This entity hires the contractors, the employees, the vendors, and the clients. It's the company that handles the logistics, hauling the loads, paying the drivers, managing the operations. But here's the key. It does not own any assets. Now, the holding company does not create contractual privity with outside parties. All of the contracts are signed by the trucking company. The holding company sits at the top. It is the member of the trucking company, which means it's the owner, so it gets paid through distributions or dividends. It's also the manager, so it gets paid through management fees. And on top of that, the holding company owns the assets like the intellectual property and the vehicles, which means the holding company can lease and license those assets to the trucking company. And in turn, the trucking company pays the holding company a licensing fee and lease payments. So a lot of you commented on my last. Welcome back to the Holding Company Series Part 3. If you have been following along, we have been learning all about holding companies. Okay, now that you know the types of holding companies, how they work, and how they get paid, let's talk about whether it's right for you. Here are some common reasons why you might want to set one up. Number one is privacy. When you form an operating LLC, in most states, they require you to disclose the name of the member or managers. And for some of y'all don't like that, especially my real estate investors. You do not want your tenants to be able to find you. Using a holding company, you can list a holding company as a member or manager of that LLC. If someone looked up your trucking LLC, they would not see your personal information. They would instead see your holding company's information. Number two, asset protection. This is really crucial for people who are in highly litigious careers and get sued personally, like doctors, architects, engineers, attorneys, real estate investors. If one of your operating LLCs gets sued, the holding company adds an extra layer of protection. The creditor would have to pierce through the operating LLC, then pierce through the holding company LLC to get to you personally. The third is centralized management. You manage everything under one umbrella while still keeping each operating company's risks separate. And if this infrastructure is set up the right way with the right attorney, the right CPA, there are phenomenal tax advantages. Welcome back to the Holding Company Series Part 4. Real estate investors, this one is for you. Here is how a holding company works for your portfolio. Start with a holding company in an anonymous state like Wyoming for privacy. That company does not own property directly. Instead, it owns property holding LLCs set up in the state where each property is located. Now, should you put one property per LLC? The short answer is yes. But as you scale, you may group properties based on things like property type, equity, cash flow, and location. Depending on the size of your portfolio, you can also add a property management LLC. This company signs leases, collects rent, handles repairs, and then passes the profits to the property holding LLCs. Those LLCs pay their expenses, and what's ever left over flows back up to the holding company. Coming up next, holding companies versus trust. When people ask me, should I set up a holding company or a trust? The truth is, it's not one or the other. They do different jobs. Let's look at their primary role. A holding company owns and controls businesses or assets. A trust, on the other hand, holds and manages assets for beneficiaries. When it comes down to ownership, a holding company holds equity in subsidiaries. With a trustee holds legal title and beneficiaries have equitable title. Let's look at protection. A holding company shields your personal assets from business risk. An irrevocable trust is the only type of trust that gives asset protection. When it comes to contracts, holding companies don't sign contracts directly, operating LLCs do. A trust doesn't sign contracts, but beneficiaries can still hold the trustee accountable. Holding companies earn income from dividends, distributions, or management fees. Trusts distribute income to beneficiaries based on the trust terms. A holding company is best for business restructuring, asset protection, and tax efficiency. A trust is best for estate planning, wealth transfer, and in some cases, asset protection. A holding company can exist perpetually until dissolved. Most trusts have to terminate after a certain amount of years unless structured as a dynasty trust. When it comes to privacy, a holding company offers high privacy depending on the state. A trust offers high privacy since assets are privately held. So what this structure looks like is the trust is at the top, your trust owns your holding company, and your holding company in turn owns your operating businesses. But here's the key. The operating businesses should be set up in the state where you are primarily operating. When people ask me, welcome back to the whole.
And at Fidelity, we believe that financial planning includes incorporating planning to transfer wealth, not only when we pass away, but also through periods of incapacity. And so today, I'm really excited to introduce our panel and jump right in. But before we do, just a couple of things I wanted to remind everybody. Fidelity does not provide tax or legal advice, and nothing we'll talk about today should be interpreted or construed as tax or legal advice. We're providing the information in a general nature. It might not apply to your specific situation. And so if you do have concerns or questions about your specific situation, we encourage you to talk to an attorney or tax professional. All right, so now let's get started. I'm excited to introduce the panel, two people I work with very closely. I'll ask them both to introduce themselves first, and then we'll get on to the first question. So Terry.
Great. Hi, Mike. Hello, everybody. Happy Thursday. In these times of volatility, we will find happiness perhaps in other places. Thank you so much for inviting me to join. I'm a vice president in the Advanced Planning Group, and I have 30 years in the industry of working with professionals like Tiffany and her clients as a subject matter expert in the area of family wealth planning strategies, which includes estate, trust, gift, and charitable planning strategies. I routinely work with clients and their families to help them craft an estate and gifting strategy that makes sense in light of their personal goals and objectives, their wealth level, and their family dynamics.
All right, thanks, Terry.
Hi, I'm Tiffany Myers. I am a vice president and financial consultant in our San Francisco Investor Center, celebrating 18 years with Fidelity and over 23 in the business. I'm here today because I believe a financial plan should coordinate well with your estate plan, and I help clients navigate that process.
All right, Terry and Tiffany, thank you both so much. So estate planning is such a broad topic. So I want to start by defining some terminology about what we mean when we say estate planning. So Terry, could you get us started, please?
Sure. So from a kind of a 30,000-foot overview, an estate plan really is making sure that you've got a legally documented, well-coordinated plan to provide for the management of your financial assets and your healthcare decisions while you're alive, as well as to make sure that you've got a plan for the distribution of assets after you pass away. So that can encompass a lot of different areas, and I think we've got some a slide up there that kind of goes through 8 or 10 different areas. We don't have time, unfortunately, to go through all those. So I'm going to pick 4 or 5 that I think are the most important. The first one is really something that everybody thinks about, which is if I pass away, where's my stuff going to go, right? Where are my financial assets and my real estate and my car going to pass? Not only who gets those assets, but the manner in which they receive those assets, right? Is that outright or versus in trust? And we'll talk a little bit about that in just a few minutes. The second area is really important, and I don't think a lot of people think about it when they think about an estate plan. And Mike, you actually mentioned it in your introduction, which is planning for incapacity. And that's making sure that you have someone who is legally authorized to make your financial decisions, as well as your healthcare decisions in the event that you're unable to. The third thing that I want to point out is an estate plan allows you to make sure that you're choosing the people to manage assets after you're gone, whether that's the distribution of the assets to your different heirs, or whether that's managing assets for younger beneficiaries or heirs with special needs. The fourth area is passing assets tax efficiently. So, a lot of people on this call have several different kind of buckets of assets. And I think Tiffany is going to talk about this a little bit later in the call. Those different buckets, whether it's, taxable brokerage accounts or retirement accounts, have different tax characteristics. And so part of an estate plan is making sure that you're passing the right assets to the right people in a way that makes sense for your overall plan. We won't want the tax tail wagging the dog, and in a way that preserves the tax benefits as much as possible. And then the last thing that I'll touch on is, in some cases, family privacy or avoiding the probate process can also be important. And so an estate plan can also touch on making sure that those goals are achieved as well.
All right, thanks, Terry. So it's a wide topic area. There's a lot for us to cover. But before we jump into the details, I think one of the questions, Tiffany, we get a lot is, well, what are the risks of not creating an estate plan? What should we be worried about if we don't create our own plan?
Well, as Terry mentioned, having a plan helps to protect you, your family, and your assets. So the risk to not having one is that eventually everyone does need an estate plan. And if you haven't created one for you, or if you haven't created your own, one will be created for you. It will be created by probate courts and family members, and they will decide what your wishes are at the point of diminished capacity or incapacity or death. So you really do want to create your own and have your wishes laid out as you want them, not as other people dictate to you.
All right, and so clearly this is something that we really shouldn't neglect for ourselves and our family. Where's the right place to start? And Tiffany, I'll ask you to keep going.
Yeah, sure. Well, it's a great question, and there's good news because a lot of us may have already started our plan by adding beneficiaries to our financial accounts. So that is the first place to start. From there, you'll want to make a list of all of your assets, all the people and organizations that are important to you to help you put your financial goals in order. So these can be goals around large purchases, college education savings, supporting parents, retirement, philanthropy, and legacy. And a financial professional will help ensure that all of your assets are structured in line with your goals. And once you do that, you have then the beginning stages of the estate plan and can go from there.
All right. Well, thanks, Tiffany. It's so amazing. You started out with beneficiaries, and I think all of us can agree one of the biggest things that we see missing from clients' portfolios as we look at their accounts is beneficiaries. So we'll hit upon this at the end, but that's certainly the homework that we'd like everybody to walk away with. But speaking of kind of the next steps, Terry, talk to us a little bit about what are the critical documents that form an estate plan, and what should we be thinking about as families start to craft them with their attorneys?
Yeah, there's really 3 different documents that I think everybody should have. And then there's a 4th one that, as the screen indicates, is kind of an asterisk that may apply to some people. So the first kind of 3 core documents really are a last will and testament. And everybody thinks about, the time that everybody goes to the attorney's office and the will is read in front of the heirs. I will say that probably happens more often in the movies than it does in real life. But nonetheless, that last will and testament is a core document. And really, in many cases, except in the case where you're using a revocable trust, and I'll talk about that in just a second, that will is going to be the document that talks about where you want your assets distributed and how. For those of you with young children, that document can also indicate who you want to be guardians for your children. And then that document will also name an executor or a personal representative that is responsible for kind of settling your estate, filing final income tax returns and stuff like that. I think Tiffany is going to talk a little bit about what those different roles are. The second document is the second 2 documents are to address the incapacity portion of your estate, or of your estate plan, I should say. And that's a power of attorney for financial decisions. That allows you to appoint someone legally to step in and pay your bills, sign your income tax returns, and kind of manage those finances, again, in the event that you're unable to. And then the 3rd document are healthcare documents, and different states call them different things. So sometimes they're referred to as advanced healthcare directives. Sometimes they're called medical directives. Sometimes they're called powers of attorney for healthcare. But in all those cases, if you combine all of those, what you're really looking at is making sure that you appoint someone to be the liaison or advocate with you and your doctor if you are unable to kind of voice what your medical wishes are. And then many times you'll also give kind of high-level instructions for what end-of-life care is. The 4th kind of asterisk document is a revocable living trust. And that can serve as a kind of a companion to a will, but really takes all of the distribution provisions out of the will and puts it in that trust as a way to address kind of privacy concerns as well as probate concerns.
Great, thanks, Terry. And so just to recap, a will, power of attorney, healthcare proxy, and we'll dive deeper into trusts in a little bit, but that plays a big part as well. So one of the other things, though, related to this that we hear from families a lot, and we just wanted to address quickly, Tiffany, sometimes there's an assumption that because 2 people are married, spouses have rights to step in and act on their spouse's behalf for financial matters or other reasons. Could you, Tiffany, share a little bit about when that's possible and when it's not possible?
Yeah, absolutely. It is an assumption a lot of people make. So if assets are jointly owned, either in a joint account or as co-trustees on a trust, you both have access. But accounts that are individually owned, things like IRAs, 401ks, individual brokerage accounts, those accounts don't automatically give a spouse authority to get information or to make any decisions. I can think of an example where someone had assumed that. We had a client come in and they let us know that their spouse was unfortunately ill in the hospital and they needed to take some money out of the IRA. Unfortunately, the person in the office was not authorized on the account, so we encouraged them to go home and get their estate documents. They were able to bring us the power of attorney document, and we were able to get things done. But you shouldn't assume that a spouse has automatic authority. Sometimes couples do plan differently with their finances, and they don't always want each other to have access to the accounts. So financial firms have to recognize that, and you need to have proper power of attorney or other authorities in place on those accounts in order to gain access and be able to make transactions and do things. The other thing that you want to make sure of is financial firms now have something called a trusted contact. This person doesn't have any access or authority on your account, but it does let us know who to trust if they come in and tell us about a change in your condition, or if we have a concern about your condition, it gives us somebody to reach out to that we can talk to about that. But again, they don't have any authority over the accounts. It just helps us know who to trust.
All right, thanks, Tiffany. And when I think about the current volatility, it does remind me of a situation where, not unlike the current market, a spouse did want to go in and access the account of another spouse, and they weren't allowed to because they didn't have the right authority. So I think it's a great takeaway for everybody. Thank you. All right, let's pivot a little bit. Terry, so we're talking about wealth transfer and estate planning, but maybe level set for us and just talk about the different ways that assets pass throughout the generations.
Sure. And I want to make one quick comment on something Tiffany said, because I want to kind of emphasize it. One of the most common pushbacks we get from clients is, well, I'm a beneficiary on the account. Remember that just because you're a beneficiary doesn't mean that you have access currently. And so just reinforcing that need for that power of attorney and that authorized access during your lifetime. So let's go back to the question you asked, Mike, which is, what are the 4 ways that assets pass? And one of those, of course, is by beneficiary. So I'm going to skip to the second, since we're on that topic, the second bullet, which is by contract. So assets that have a beneficiary designation on them will pass according to that beneficiary designation. It doesn't matter what your will says. It doesn't matter if you have a trust and it says something different. The beneficiary designation wins. The second way that assets pass is by probate. And what that really means is through your will. So if you've got assets that are in your name only, or perhaps own joint, but as tenants in common or as community property, that means that your interest in those accounts are going to pass according to what your will says. When you pass away, your will gets filed with the probate court, and then that probate process kicks in. The third way that assets pass is if you own assets joint with right of survivorship. And that means that if something happens to you, then that asset automatically will pass to your surviving spouse or surviving account owner, as the case may be. We see real estate often titled in the name joint with right of survivorship. So it kind of is the default for a lot of real estate agents and title companies. And then the last way that assets pass is if you have assets owned by a trust. And the trust then will give instructions for how those assets pass when the grantor or creator of that trust passes away. Those generally don't talk to each other. So just keep that in mind. If my will says that I want assets to pass to Tiffany, but I have all my accounts designated to pass to Mike, Tiffany is going to get cut out of everything, right? So it's really important to make sure that when you've got your estate plan in place, that your asset titling and your beneficiary designations are coordinated with your documents.
Terry, that's perfect. And I was about to talk about harmonizing all this together. And that's what estate planning is. It's not just selecting one of the 4. It's making sure all 4 are working together, or 3 at least. And if you need a trust, it's making sure they're all working together. We do see a lot of scenarios, Terry, like you mentioned, where there's an assumption that a will is going to supersede a beneficiary designation and vice versa. And unfortunately, sometimes that happens when it's too late. So, all right, thank you. So Terry, let's talk about trusts. We hear a lot about trusts. We got a lot of questions from the audience about trusts. So why don't we start with the real easy question of, who might need to consider having a trust?
Yeah. And because we have so much to cover, I'm going to be pretty quick on this section, but I do want to let everybody know that we are going to have a follow-up Insights Live webinar on April 16th called Ask Fidelity Anything. And I think they're going to spend a lot more time talking about trusts. So for today then, let's just make sure that we kind of have a high level understanding of the two big kinds of trusts, which are really revocable trusts and irrevocable trusts. Revocable trusts are trusts that you can change. That's the term revocable. And those are the trusts that are most commonly used when we're talking about setting up a kind of a core estate plan for someone. Irrevocable trusts are just what they're called. Generally, once you set them up, they can't be changed. They're used a lot for people who want to do significant lifetime gifting as a way to structure those gifts. And then those irrevocable trusts can also come in play when it comes to how you're passing assets to heirs, whether that's to a surviving spouse or whether that's to children or other family members or friends that you want to put some sort of structure or even potentially guardrails around those. So those are the two big types of trusts. From a revocable trust standpoint, though, the primary reason that most people will use them is first and foremost to avoid the probate process. So depending on where you live, the laws in the state that you live in are going to govern whether the probate process is an easy one or a hard one. Here in California, our probate process is very complex and expensive and can take a year to 2 years to get through. So revocable trusts are very common for us to try and avoid that probate process. In other states, Texas and Washington are two that come to mind. Their probate processes aren't as complex or difficult. And so revocable trusts may not be as common in those states. So the thing I would just suggest is when you're talking to your family and friends about your estate plan, and for those of you who have attorneys who say, hey, we really should do a revocable trust, and you've got a brother in Texas that says, I don't have a trust, you don't need one, know that he's probably not familiar with the laws of the state that you live in, and so may not realize or understand why that trust may be important for you. The other reason that people have trusts is for privacy. So even in states that the probate process isn't a big deal, sometimes people want their distribution plans kept private. When we have a will, generally that will gets filed with the probate court, and in a lot of states, that will is then accessible by anybody who wants to look it up. When we have a trust and we have all those distribution instructions contained in the trust, nobody gets to look at the trust except the beneficiaries and the trustees of that trust. So we put a little privacy wrapper around it, and we allow for kind of other people outside of the family to kind of be kept in the dark about what our estate plans are.
Thanks, Terry. And I think one of the big takeaways to answer the question, who might need it to consider a trust, is it's really dependent on what you want to accomplish with your estate plan. Yeah. So like you said, just because your neighbor or your friend has a trust doesn't mean that's right for you, and vice versa. So that's great advice. Thank you. Well, so the documents themselves are really just the paper that we write down our wishes on. Everyone's going to depend on people and individuals to actually bring those documents to life, execute your wishes, and make sure that your plan is actually put in place. So Tiffany, can you talk a little bit about the different roles in those documents?
Yeah, absolutely, Mike. So there's 5 key roles to consider. There's the executor, guardian, trustee, power of attorney, and healthcare proxy. So the executor is the person who will settle your estate. They're going to pay all your final bills, final taxes, help with distributions, and do the final settlement of the entire estate. The second is the guardian. So this is especially important for people with minor children. This is the person who will care for your children if you pass away before they are 18. This isn't necessarily the financial guardian for the children, but it's the person who will raise that person or people that will raise them. The third role is the trustee. So the trustee takes on all administration powers of the trust. And while you're alive and well, this is generally you. But if you become unable to serve, then your successor trustee steps in. So this person will administer the trust, handle all the finances. If the assets are not professionally managed, they'll have to manage all of the investments. They'll have to follow all of the rules and instructions set out in the trust. And this role is incredibly important and has enormous responsibility. So anybody who serves in this role should understand the responsibilities, have the time to do it, and be willing to as well. And then we have the power of attorney, and Terry touched on this a little bit. So the power of attorney is a person who's legally responsible to act in your best interest, generally over all your financial accounts that aren't part of your trust. If you do have a trust, this power of attorney and the trustee could be the same person. But this person will handle retirement distributions, other financial affairs, paying your bills, that type of thing. And then finally, we have the healthcare proxy. So the healthcare proxy is in charge of all your medical and end-of-life decisions. They're there to follow the instructions that you've set out. This person can be different than any of the other people that I've mentioned so far. And so with the healthcare proxy, it's important to note here that your spouse does not have this automatic power. I think we've all heard stories where there's somebody who is hospitalized without a healthcare proxy, and the spouse and other family members like parents might not necessarily agree on the care that should be given. So it's really important that you have the healthcare directives and name the healthcare proxy so that they can carry out your wishes. It's also really important that that person be willing to carry out the wishes that you've laid out. So just in summary, we have the executor, guardian, trustee, power of attorney, and healthcare proxy. So lots to cover there, but I'll send it back to you, Mike.
All right, thanks, Tiffany. Yeah, there's definitely a lot of responsibility with the individuals that we nominate and select to fulfill these roles. Terry, if you could talk a little bit about how our clients and families can start to think about who might be appropriate to fill these roles and some of the factors that we should consider, because I think the instinct sometimes is the closest relative or the family friend, but there's a lot more that goes into the decision than just that.
Yeah. Or the oldest child, right? We hear that a lot from clients. It's like the path of least resistance, and that might be the least, the least good. I know that's not grammatically correct, but you understand where I'm going with that. So there's a lot to consider. And as Tiffany indicated, there's 5 different roles. You could have 5 different people filling each of those roles. I would say it's probably not common. Usually people group kind of the financial related roles together and then the healthcare related roles together, with the guardian kind of following somewhere in the middle. But there's probably 7 or 8 different things to think about. So the first is how old are the people that you're thinking about naming? So for younger clients, a lot of times, they're not married or don't have spouses or partners yet. And so they look to their parents to fill those roles, which is probably fine for a certain period of time. But, everybody's getting older every day. And sometimes these documents get put in place and then don't get reviewed for years. And so just keep in mind that at some point, if you're naming someone who's older than you are, that they may not want the responsibility of paying your bills and filing your tax returns. They may rather sit on a cruise ship and be sipping wine instead. So age is a factor, as is on the opposite end of that spectrum, right? If you've got children who are young, perhaps you don't want to name them today, but know that you can name them as of a specific age, right? So you may have someone step in and say, look, until my middle child is 30, or pick an age, then I want this other person to step in until that time period. So we have a lot of flexibility with that. The second consideration is proximity. So where do they live? For clients that have relatives or friends or family that are living abroad, to think really carefully about whether they're appropriate choices, even though they may be the primary choice that you would want. We want to be sure that we name someone, just to make it easier on them, who has some sort of familiarity with US, tax laws. Even if we're naming someone who lives across the country, right? So I'm in California. If I name someone in New York, I need to think about the practicalities of, if I end up in a hospital bed, how are they going to make medical decisions for me? A lot of the financial stuff can be done digitally now. So it's a little bit easier to name more remote people to those roles, like the agent under a power of attorney, or an executor under a will. it can still cause some difficulties if you name someone who lives far away. The third consideration is objectivity. So if you've got 3 children and you're naming one to the role of executor or successor trustee, they're going to be put in a position of responsibility and power over making decisions relating to the distribution. So you may think it's really easy and I'm leaving it, okay, a third to my 3 kids. But that third can have wild differences as it relates to the type of assets each child receives, right? One child could get the house and another child could get an equivalent amount of other stuff. And so how objective is that, middle child going to be when they're fulfilling your distribution wishes? You also want to look at experience, knowledge set, skill set. Have they settled in a state before? Have they acted as a trustee for someone else? Do they have professional experience that might make them more applicable to do that role? Are they a CPA or are they an estate planning attorney? Do they work for a financial institution as part of the advanced planning team? I know that certainly went into the decision that my father made. I have an older brother, so you would think he would be the natural choice. However, he has zero desire to do any of this stuff, and it happens to be what I do for a living. So I get the burden, quite frankly, of doing that for him, although of course I gladly do it. The second, third, fourth, fifth consideration is bandwidth. So if you've got a child who is in prime working years with 2 young children, are they really going to have the time to be able to devote to really fulfilling the role in a way that makes the most sense? And then the last thing is family dynamics. So if you've got 2 children who you think, I don't want to choose one because I don't want one to feel left out, you have to think about how they're going to act together. Those roles can have a lot of stress and responsibility and constrain relationships. And so you want to be sure that if you're going to name more than one person to act together, that they have the ability to do that. You also have the ability to allow them to divvy things up. So you can name 2 people who can act independently. And so, maybe you say, look, you have a responsibility for paying bills and the other one is going to have responsibility for filing tax returns. And usually we kind of let them work that out. Although having discussions with them in advance, I think we'll talk about that in a little bit, can go a long way to making sure that any of the people that you assign to these roles kind of know and understand what their responsibilities are and are willing to do it. Ask them, once you decide in your mind who you want to name to these roles, ask the people that you've named. There's no requirement or no legal responsibility that they have to say yes. And so you want to be sure that they're willing to do it. And then unfortunately, it's not a matter of figuring out one person for each of those roles, but you really should have at least one backup. Life is uncertain. People's lives change. Maybe they don't have 2 children today, but maybe in 5 years when you need them, they do. And so we want to be sure that we have kind of a plan B and C as it relates to those roles as well.
Thanks, Terry. That's great. There's obviously no formula, right? There's a lot of different factors to go into this. The one thing I did want to pull out of what you just mentioned is this isn't a set it and forget it. People's stations in life change over time. So it's one of the reasons why it's always important. And I think, Terry, you'd agree, one of the things we see a lot when we work with families is sometimes the person we chose 5 years ago isn't the right person now. So keep that in mind as you go through this process. But Tiffany, one thing that does come up, there are people who either, like Terry mentioned, just don't have family members that they'd like to fill this role, or just don't have those people close by to serve as an executor or a trustee. So quickly, tell us what the options are for someone who finds himself in that position.
Yeah, absolutely. So there's 2 options. The first is a corporate trustee. So this is a firm that has a professional trust company associated with it and has people designated that can act as trustee, generally with a group of asset managers. Fidelity has Fidelity Personal Trust Company. So that's an option as well. And corporate trustees, it's important to note, they can also act alongside a family member, so that the corporate trustee takes on all of the responsibility of managing the assets, of doing all the financial matters and paying bills and filing taxes. But a corporate trustee is an option. For some of the other roles, the option would be a licensed professional. So there are professional powers of attorney and healthcare proxies that you can hire. Sometimes they're attorneys, but you do want to make sure that they're properly licensed and that they're fiduciary, which means they're acting in your best interest at all times. But there is an option to have a licensed professional as well.
All right, thanks, Tiffany. So Terry, back to you. This is a big one. This is a question we get a lot, and there's probably a lot to it. So maybe focus on the headlines, but the process of settling an estate. I know you mentioned it definitely does vary from state to state, but can you just sort of share what that high level process looks like and some of the things everybody should be thinking about?
Yeah, there is a lot there. And this could be a whole separate webinar. Fidelity does have a lot of resources. And so fidelity.com/estate plan is a great resource for clients who are looking for additional information. So Mike, I will try and keep this really high level, and I'll try not to speak a million miles an hour, but perhaps just 1,000 miles an hour. So some of the things that go into settling estate. So first and foremost is you need to organize all the important information, right? The will, the trust, the death certificate, current tax returns, gift tax returns, get them all in one place. Determine the need for the attorney. So in some cases, if it's a really simple estate, perhaps the executor does it on their own. In other cases where we've got more complexity, or perhaps we have an executor or trustee that isn't as familiar with kind of the estate settlement process, they'll reach out and bring in the assistance of a CPA or an estate planning attorney. And I will also say that in a lot of cases, our professional advisors, financial consultants here at Fidelity are key kind of pieces of that advisor team to help make sure that we provide as much help with clients and their executors and trustees as possible. The will has to get filed with the probate court, and this gives the executor the authority then to continue with the estate settlement process. We have to determine whether there needs to be a probate. That depends on the size of your estate, and that depends on the state that you live in. There's a possibility that there's no probate, or perhaps we have a small estates probate or a full-blown process, right? So it depends. And then there's all the notifications that have to happen, right? The beneficiaries, financial institutions, Social Security Administration, the post office to have mail forwarded, utility companies, credit bureaus, mortgage companies, cancel subscriptions, pension plans, right? Employers. So a lot of people to reach out to. You want to take an inventory of assets. So what did the decedent own? We need to value those assets, and in some cases, we need to get appraisals of those assets. So if it's not just stocks and bonds, and the client has a home or a business, a lot of times we need an independent valuation company to come in and value those assets. You want to be sure that you're considering things like employee benefits plans, so 401ks, life insurance policies, equity compensation. And you also want to be sure that you're paying attention to required minimum distributions. If the required minimum distribution for those who have already started those haven't been taken already before they pass away, it needs to be done by December 31st of the year they pass away. You might want to consider setting up a bank account to collect money that comes in, right? Final wages, insurance benefits. That will allow you then to have the money to pay debts, lawyer fees, funeral costs, and that will require getting a tax identification number for the estate. And then of course you have to pay taxes. That could include things like a federal estate tax return for federal estate taxation, a state estate tax return, individual income tax returns, both on a federal and potentially state standpoint, and then an estate income tax return, right? So which is why I mentioned some clients or some people choose to enlist the help of a CPA or an accountant to help them with all that. You want to be sure that all the debts get paid off. This should come from the deceased's assets, right? I do get questions about, well, if I'm an executor or a trustee and the person had debts, am I personally responsible for those? And the answer is no. Those should get paid by the decedent's assets. And then, of course, asset distribution, right? Making sure that the terms of the will or the trust get carried out. And then finally, you need to close the estate. So if the estate has gone through a probate process, that involves filing a petition for discharge of executor responsibilities so that you can draw a line in the sand and say, I'm done. And then asking the court to kind of formally close out the estate.
Thanks, Terry. And it's pretty clear, why choosing the right people to help us with this is so critical, because that is a long list of responsibilities. And again, not every estate will go through that, but it's certainly possible. And one of the other questions we get asked in this area is, how long will it take? How long will it take to settle an estate? So Terry, I'll ask you to keep going a little bit.
Yeah, you're asking me the impossible question. And the answer is it depends, right? Nothing is ever black and white in the world of estate planning. It depends on a few things. The first thing is it depends on how organized and coordinated were you, right? Do you have a will and a trust in place? Was your asset titling and beneficiary designations coordinated with that? The second consideration is, where did you live? Is it an easy probate process? Is it a hard probate process? And then the third is the complexity of your estate, right? If you have someone who owns, 2 accounts at Fidelity and they have beneficiary designations and that's it, maybe that's really easy. If you have a client who has, not only financial assets, but they have a house and they have a business and they have a complicated estate distribution plan, that could take a lot longer. So you're looking at anywhere from 6 months to 2 years in general. And we have seen estates that take 3, 4, 5 years if kind of kinks come up in the process.
Wow. And I also think it's important, and everyone who's gone through this will know this, but there is an emotional component to this. So we're talking about sort of checklists and things that have to get done, but it's important to remember that these things that have to get done sometimes are being done under the burden of losing somebody that has been so close to you. And that devastating loss can really make this feel a lot longer as well. And it's important to keep that in mind as you're preparing your own estate plan. What are some of the things that we can be doing to make it easier on our heirs? And so, Tiffany, speaking of the heirs, can you talk a little bit about that and how we can help them manage through the process and understand all of our wishes?
Absolutely. And Mike, you make a great point that a lot of these roles are carried out in times of great sadness when somebody's mourning either the illness or loss of someone, and that puts an additional burden, which is why it is important to also have a financial team that can help kind of guide them through and take some of that burden or stress away. The 2 things that come to mind with heirs specifically are organization and conversation. So with organization, I think we've mentioned a number of times here, having your documents organized, having things titled properly, and having beneficiary designations, and all of those things coordinated together to say the same thing are really important. So hopefully everybody sees how important that is because we've mentioned it a few times. The other thing is to keep your documents in a secure and known place. So if you have hard copies of your documents at home, they really should be in a fireproof container, and someone should know where to find them. And you can store documents securely and electronically. Fidelity has something called our FID safe, where we allow clients to upload all of their documents so they can be stored in case their executor or heirs need to come in and have access to them when someone passes away. And then around conversation. So this is important, but it can be a little tricky. So the one conversation that has to happen is to make sure everybody in those 5 roles knows their responsibility, is willing to act, and has the time and capability to do so. So talking to them about that is really important. The other thing that's really important to talk about is preparing your heirs for the inheritance. What does that look like? What things are important to you around the assets or philanthropy or things that you've incorporated in your plan or you want to see them carried through? The other aspect of that is really important, especially if your money is not professionally managed and it's something that you've built and bought different companies and other things like that, is leaving instructions for your heirs of what you would like to see, and that might entail like it's okay to sell out of that stock that I've had for so long. Because sometimes heirs and recipients of assets can be a little bit paralyzed if they're not sure what the wishes were, because it's a bit of a legacy to them. And do I carry this on and keep everything intact? Or can I sell some of this and use it to send my kid to college or to buy that home that we've always wanted? And so it's good to leave instructions if you feel comfortable. And there's just a couple things that come to mind with that. One is that I did have a client that wasn't as comfortable having that conversation with his kids, but did have that conversation with his financial team. So when he passed away, we were able to have discussions with the kids about those wishes and make them feel more comfortable and confident in changing the investments to really align to their specific goals, which were obviously very different from their fathers. But the other thing I wanted to bring up is I use the analogy of maintaining a home. So if you own a home for multiple decades, we all know that home requires repairs over time, repainting, remodeling. You might want to change an office to a nursery, and you might need to replace appliances or add on a little room. And so if you do nothing with the home over decades, we all know that it can deteriorate, it becomes less valuable. And a portfolio is the same way. So the portfolio should be properly maintained once it's passed on. And it's good for your heirs to know that it's okay to do that, that they need to maintain it over time and change different things about it so that they feel comfortable to do so and really can efficiently use those assets for themselves and their families.
All right, thanks, Tiffany. I think you hit upon probably one of the most important pieces to this whole process. You mentioned communication, and we've talked about it a lot. So very quickly, how do you forge communication between couples in this process to make sure that everybody's on the same page?
Yeah, great question. So my team knows that for planning couples, both parties are always invited to the meetings. They're CC'd on communications as it relates to their financial plan and any follow-up that comes from those meetings. But at any couple, everybody kind of divides and conquers with the different duties and responsibilities. So there's usually one primary financial decision maker. But I do encourage the non-primary decision maker to join discussions, especially as it relates to their financial plan or their estate plan. So with couples, it's important to talk about the goals that you have and things that are important to you, but not every couple has the exact same goals or prioritization of those goals. And both of them generally don't share the same concerns in efficiently reaching those goals and navigating the process. So that's where a financial professional comes in to really help them find a middle ground on some of those things and create a plan in which both voices are heard and reflected. So even though there's generally one primary decision maker, it's really important for the non-primary decision maker to be involved in conversations, maybe not every single conversation, but at least so that your plan reflects both persons' wishes and goals.
All right, and sticking with communication, and I was looking at the time, so Terry, we've got a lot of other questions we still want to get to, but very quickly, one question we get a lot is, well, how much should we share with our heirs about our plan? So could you quickly share your perspective and what you've seen?
Yeah, I think the thing to keep in mind is that the decisions that you're making today can have long-term effects on your heirs. And that's both on them individually as well as the relationships they have with each other. And most clients that we work with want to leave a positive legacy for their heirs. And so we encourage clients to be as transparent as they're comfortable with their heirs. And that can mean everything from kind of high level communication about distribution all the way down to really kind of opening up the cupboards and saying, here's what my net worth is, here are the specific bequests I'm making, here's what's going to charity. Of course, you want to be sensitive to age, you want to be sensitive to kind of emotional readiness for those conversations. But I think it is really important to know that while you have the vote, you are the legacy that you're leaving will affect your heirs, and we would encourage you to at least give them some voice. And that may affect the decisions that you're making as well. Again, Fidelity has a lot of resources in this area as well. And so I'll direct again back to that fidelity.com /estate plan for additional information, essentially on doing what we call family meetings.
All right. Thank you both. We're going to pivot a little bit. Any conversation about estate planning probably would be incomplete if we didn't touch upon taxes quickly. So Terry, if you wouldn't mind, just high level the landscape of the estate tax situation right now.
Sure. So we've got a current tax act, the Tax Cut and Jobs Act, that was started in 2018 and set to sunset at the end of this year. That means that we have the ability, other than passing assets to a spouse or charity, which is unlimited, we have the ability to pass up to $13.99 million per each of us to any number of heirs, right? That does sunset at the end of this year and will get cut in half, unless, of course, Congress acts. There is legislation that is currently in the process right now that I think largely seeks to extend a lot of the provisions of that Tax Cut and Jobs Act, and one of those would be the extension then of that, what we call a state exemption amount. Just know that even if Congress passes something today, it's unlikely to be permanent, just given the current makeup of the House, Senate, and White House. And even if it were permanent, there's no such thing as permanency in tax laws. And so what kind of this Congress and presidency can do can be undone in 2, 4, 8, 10 years. And so it's something that we here at Fidelity are constantly monitoring and trying to make sure that our clients are fully aware of everything that's going on in the legislative and tax landscape.
Well, thanks, Terry. And I think the other thing to keep in mind with taxes is, one, there are state level state estate taxes as well in several states. So in addition to watching the markets, maybe we're also watching our legislative tracking resources to figure all this out. All right, so let's move ahead a little bit. So Tiffany, when you work with clients every day in an estate planning capacity, can you talk to us exactly about what that looks like and how you and Terry and others can help families?
Yeah, absolutely. So your financial professional is here to help. If you haven't had a meeting, please reach out to your financial professional and inquire about the resources. You can also use Find an Advisor on fidelity.com. We also have a lot of educational resources like this webinar, or Fidelity's Learning Center and other articles and videos that you can watch that will provide you additional information. And finally, we mentioned a couple times, but we have tools. So Fidelity's Estate Planner, which you can find by just searching that on our website, or the FidSafe, which is where you can store electronic copies of your documents.
All right, thanks, Tiffany. Terry, I think we're almost at the top of the hour. And so just to wrap and follow up on what Tiffany was mentioning, at Fidelity, we believe that financial planning includes estate planning. It's a core part of what we do and how we help our families. And in addition to some of the resources that Tiffany referenced and that you've seen during the last hour, the way that Fidelity can also help is not only get you organized through the FidSafe program or the Fidelity Estate Planner, which has that opportunity to identify attorneys, but as Terry mentioned and Tiffany just concluded with us, it really all starts with reaching out to your advisor. So on behalf of the entire Insights Live team, Scott Adams and Strategic Advisors, and me, Tiffany, and Terry, we just want to thank all of you for spending time with us, especially during this week. And hopefully you found this helpful, and we look forward to working with you in the future. So thank you very much.